Moving forward to our panel discussion on patent eligibility in the era of emerging technologies, navigating the patentability of AI systems, software innovations, and biotechnological breakthroughs in the global legal landscape. Please welcome Mr. Praveer Gupta, the Director, Patent and Innovation Strategist, Unifor.
That's me. Yeah, we'll come together. That's fine.
Okay. And also Mr. Bao Tran, his Journal Partner, Transformation Venture.
Yeah.
I'll leave the stage to you now.
Okay, great.
Yeah.
Well, thank you everyone for joining us in this exciting session on AI and patentability. My name is Bao Tran. I am a general partner of Transformation Venture, and we're an investment firm, but I've spent 20 years in the patent space, starting with patenting the Invisalign patent portfolio, and then also the Shutterfly patent portfolio. So since those days, we have significant changes in software patentability questions, and also the emergence of AI as a technology. So we're lucky today to have Praveer Gupta, who is the director of Semaphore. It's an AI-based voice processing company. We will cover three topics, mainly first, how do you provide an application that is transportable across the different jurisdictions? Namely, is it possible to do one application that would be portable into, let's say, Europe, China, maybe Brazil, and the US, right? Then the second question is, how do we deal with the common 101 rejection issues? And then the third question is, how can we use examiner statistics, and what kind of tricks and tips that we can do to improve our overall allowance? So Praveer, you want to talk a little bit about your experience?
Sure. So I'm Director of Patents and Innovation Strategy at Unifor. Unifor is a business AI platform. We make solutions for enterprises that deal with specifically highly regulated data environments. So think of banking, think of telecom. We've erstwhile been a call center solutions company. So we have had significant expertise in language and speech. That led us to develop a platform that has small language models on the top layer, working with the large language models in the back end. In several cases, we can actually work without them. So what we're now doing is we're building enterprise class solutions, agentic structures using these models. That's what we do right now. As far as patents and strategy goes, my personal belief is, because I've been in-house and as well as I've been an outside counsel for a while, so my philosophy is a lot more about enforceability and detectability. So patent eligibility for me is one of the key tenets for enforceability, and it's also a path to detectability. So as long as, if you're not somehow in software especially, and by the way, for anybody who was expecting a biotechnology discourse here, we're sorry, but our colleague who was to talk about the biotech was not able to join. So it's just the two of us. We both work mostly on the software side. But it so happens that the patent eligibility factors also come very close to the enforceability factors. There's a lot of overlap there. And what Bao and I will try and do is go through each of these topics in an interactive fashion where he will or I will, thesis something, and then we will sort of have a discussion around it. We would also be open to you guys having questions in the interim. And maybe before we go ahead, Bob, we can ask the room if there are any special topics that you definitely want to sort of, talk about. Is there anybody who actually deals with software patents or AI or other like that? You do? Okay. What is the context?
Immigration processing.
Oh, there you go. Okay.
Yeah, so we're getting into, I actually do have a question about the way you use the small language models layered over the large. So that is basically the theory of agentics, right? Because
Yes.
you're creating specialized agents in specific
Correct.
areas. So, and process manager kind of brings all of the information together.
Yes.
So that's what you guys are doing, but you're doing it on an enterprise level.
Yes.
I would love to talk to you after.
Absolutely. Go well. All right. So that was a more of a business segue, but yes.
Sorry.
No, that's good. I'm all for it, man. So, but let's talk more IP now. We can start with how the innovation intake is at my company. Is that what we want to start
Yes,
with?
that'd be great.
So we can start with that as to what I'm doing and why, and then we can go on to the harmonization across the world that Bao was talking about, and how that differentiates from, because Bao handles both hats, right? You do outside counsel, in-house counsel. I also do outside counsel, but my work is mostly nowadays in-house, and how I look at it, and then we can go further through the stack. Okay, so the first things, right? Innovation capture is where it all begins. From my perspective, my role sits between product and technology and legal. And I'm very, very focused on sort of these business pathway aligned patents or innovation. So I actually talk to almost all leadership, technology leadership on the VP, at least the VP levels. I'm talking to them, the CTO org, I'm talking to them on the product org, and I'm even talking to marketing and sales from time to time to understand what is the latest problems they're getting. And I'm usually asking them, who are you working with on the technology side, so that we can put a team together and throw some ideas and file a patent. Now, as I was talking to some of the colleagues earlier, we filed some of them, and we actually gotten some very broad patents because they were really early on. How defensible they are in court is a slightly different matter, but they're definitely valid, enforceable in general. But whether we'll get prior or not is different. The point I'm making is that we try to catch it early. And the other thing that we have done is we've used the Jira workflow, which the software engineers use. We've used that to make a questionnaire for information disclosure. So I usually encourage my company folks that don't worry about writing the whole level of detail. Just write one sentence and I'll take it over from there. That usually helps them a lot more, because the moment they have to draft like a full disclosure form, that happens in larger companies, they get intimidated. It's never going to happen at our stage of company. So that has been one of my key success factors. The other is the workshops I hold every year. We have, for a small company, like less than 1,000 people, more than 800. We have offices in Palo Alto here, New York City. We have Israel, UK, Spain, and then 2 offices in India. So it's a lot of spread, but I hold workshops everywhere, and that leads to a lot of idea generation. And then they all go through this tool, which comes in to me. The other thing I'm working on currently, because this is an AI thing, is I'm trying to piggyback some LLM or SLM models behind this questionnaire that can actually help the inventors make the disclosure a little more comprehensive. So for them, it will not feel like too much of an effort. It'll just take say a one-line description. It'll ask a few more questions. And usually that's a lot easier for the technologists than for them to have to answer a static question. They respond a lot better to dynamic questions. And you can ask the same questions, they'll answer it conversationally, and you're done. And then by the time it comes to me, we will actually have a first cut of prior art searches done. So that when we are evaluating the next step after the intake, the next step is an internal committee of, sort of evaluates it from a business perspective, from a tech perspective, and then from an IP perspective. The 3 of us basically say, okay, it's a go for patent, or it's a go for publication, or it's a trade secret, or we just abandon it. That's our process. I mean, I told you what our process is right now and where we are going. And these are not like anything that are trade secrets to us, so I'm very happy for you guys to share.
The intake you said from Jira to ChatGPT, you've done the integration?
No, we are doing it. It's not. We are not going to use ChatGPT though. We're probably going to use something that's like Claude or something else.
Yeah. Okay. But anyway, I mean that integration is a future thing.
It's
so right now
ongoing.
just-
It's just the static. Yeah, it's just a static Jira. Yeah.
For intake.
Yeah.
All right. Thank you.
Oh, that's fantastic. You've traveled many jurisdictions in the various offices. So I assume where you have offices, you will patent there.
We are right now focused on the market. So again, budgets are hard to come by. US stays our primary focus. India, because a lot of our development happens there. One of the things, Europe is important. We filed a few patents in Europe also. But one of the things that I'm testing on, and I would actually welcome your views and others also, is that especially in SaaS space, it's not like you can have one product in the US and another in Europe and another in India. It's usually going to be the same product. So if you're gonna have to make changes, you're gonna have to make changes everywhere. And from that perspective, we are falling back a lot on the US for our use case. This may not apply to everybody. For our medical devices, this is definitely not the strategy. But for our cases, we are heavily into the US and in some cases in India, because if it's very critical. Some of our other markets are Middle East and Southeast Asia, Japan and Korea. So selectively we will pick those jurisdictions, but I have done that a lot in the past, so I can speak to all of those jurisdictions also. There's not much of a patent regime in the Middle East, for example, right? It's mostly a registration regime. In several Southeast Asian countries, it's the same. Japan and Korea do go through a strict examination, so does India, but it's very close to Europe. So European jurisdiction, usually the technical effect step usually gets you past everything in these countries also. I'm doing European prosecution by proxy, if you will. Right?
Well, it's very interesting because if you're doing the European by proxy, they're based on technical effects and characteristics, right?
Correct.
And it's interesting that globally, China and the US, they kind of follow the technical effect as well.
Mm-hmm.
And so I think, to me, one common thing that we should do is in describing the specification is to go into the technical effects and the characteristics, right? Now, the claims are going to differentiate it, and then that's where you're going to need local counsel and work with local counsel to customize it, for the European practice or for the Brazilian practice or whatsoever. What's your experience and how you work with local counsel in a cost-effective way? Because most of these external counsels, their biggest profit margin is in the translation, right?
That's right. And we're increasingly seeing a lot of AI tools try to take that over, and it's actually becoming feasible now to think about, hey, if Brazil is a good enough market for us, do we want to go there? It's actually is helping because those cost reductions are significant at every stage. Not only just the filing stage, but also at the prosecution stage. It can be sizable reductions. So it's possible for our business, though we are not using it, but in my outside counsel life, I know for a fact that a lot of customers or my clients would have actually gone ahead and filing these. Now, to your original question, how does this translate? There are two important facts, and you touched on both of them. It's the claims and the specification. Now, it's been elusive, right? To be able to draft a patent claim, that will work both in the US, and it'll work in Europe, and it'll work in China, and it'll work in all these other jurisdictions. It's been an enigma. It's not very easy to find. In many cases you can, but what I've seen eventually is that there is some amount of change that's required. So what I've resorted to is to fall back on the specification. That my specification is well endowed or well filled up with a lot of technical subject matter and a lot of improvements. One of these things was, this was an IoT software patent that I prosecuted in Europe, and we had everything in the spec, thankfully, and it was a very broad patent. The claims that were already issued in the US were rejected summarily in Europe, and the examiner was very stuck that, oh, this is exactly like, and the thing about Europe and the US is that the laws are slightly differently worded, but the case laws have actually gone in slightly divergent directions. There is some sort of unification now with the technical subject matter and the 101 analysis and other determinations, abstract subject matter for that matter, for example. But for the most part, the case laws are actually quite divergent, in my view. So we had to reform the claim a lot. And then because we were reforming the claim, we relied on our specification. The specification did not have those exact words. So we were allowed to put the same language in the specification. So which would be considered new matter in the US. But in Europe, you can actually, if you can derive some language clearly from the drawings or the spec, you can actually add that to the spec and to the claim. So, but there you have it. The key, in my view, to your question is you can try to put in a lot of technical advance in the body of the claim that is going to help. But one claim draft that will work across is really hard. The easier part is to put it all in the spec properly.
Yes, yes. So I love long specs, like 100-page specs. The problem with that is when you go international, like
It's
we were,
expensive, yeah.
we got a quote from Vietnam. They allow you like 10 pages,
Yeah,
and then after that you start paying.
yeah.
So how do you deal with that?
Yeah, it's a problem. In India also, there's like a 20-page limit. Thankfully, US is like 100 pages,
Yeah.
right? Somehow, my drafting style has always been that I've never exceeded 20 pages for some reason, right? Not never. I would say 90% of my cases, I usually will finish up. And so that goes into my initial, a lot of work what I do internally is to, whether we're sending it outside or we're doing it in-house, that my team is doing, I have a strict control over claim 1 and over the drawings. And my usual thing is the storyline has to complete, start and end within those drawings, usually no more than 6 drawings. Now thankfully, software allows for that. The moment you go into any different kind of an elaborate system, it becomes difficult. But SAS usually, I mean, if anybody's familiar here, usually any invention can be typically explained away with a server where your software is placed and then a web access to it. You might have certain services that the server is using, and then there's some client devices that actually consume the service provided by the server. So that's usually like 3 to 4 drawings, maybe 5. In some cases, there are some user, method flow diagrams, but I rarely exceed 6 drawings. For 6 drawings, 20-25 pages usually do the trick, right? The key always is, especially in the AI side, which I'm doing a lot now, is it's not sufficient to say in claims or otherwise that do this method using AI. I mean, if you do that, you're gonna be like, you have to say more. You have to say that you're using a neural network, which is assigning certain weights to certain things. You have to talk about the pipeline, the data pipeline. You have to talk about how the data gets transformed, what the output format is, and how you interpret the output. Unless you're putting all of that stuff in the claims, even the US now is pretty severe with that. So that's one. And the second thing I do in the US especially, because I know, is I kind of shop for the art unit. So I really like to write my title and my abstract and preambles in such a way that they not go to 3600.
Right. Yep. There's even software that helps you
That's the software technical art
to
unit,
avoid.
which is where the patent applications go to die. So I would say that, do not. I actually have an anecdote about it later on.
Yeah, I have another anecdote. So we had a case that unfortunately went to 3600, and you can tell the examiner just said, "No way in hell," and "No way in hell" twice. And unfortunately, our skin got saved because I think was that a week or 2 weeks ago, the new director generated a new opinion, and that basically says, the U.S. is going to allow AI patent, right?
Yeah.
So that case that I was going to give up and abandon got saved because of that opinion. We immediately swing around, file an appeal brief, and then we said, and we requested pre-appeal review, and the only argument, I didn't bother to put anything else, I just slam in the opinion by the new director, and that's it.
Oh, I love it. I think I can use that. There's a case I abandoned, went abandoned because the inventor was just like, this is not going to work, but I think now it is. And this is the case where the examiner thing comes into focus. This examiner was an art unit 2800, and he actually gave us an allowance. Like he said, claim 1 is rejected, but claim 4 is allowed. Like claim 4 there's no rejection. So we were looking at an allowance, and so I said, okay, I'll take the allowance, and I argued a little bit against claim 1. And we had this interview in which I explained the invention more to him. The bugger used the understanding against me. He did more searching, and then he comes up with his prior art. And I said, well, what happened to you? Right after he gave me a final rejection, what happened to you? Why are you doing this? Like the inventor is a small guy, and you could do this later on, or there does not seem to be any need to do this. He said, oh no, actually I'm becoming a primary, and I'm moving to RT 3600, that's why. So the guy who moved from RT 2800, because he moved to 3600, he then just slammed us with 101 rejection. He just slammed us, and his entire basis for 101 is actually coming in from the prior art. Like what, so he's using prior art to say that the rest of your claim is, and that's the other nexus between 101 and 103, which is sort of convoluted in the US.
Blended in together.
It's blended in together, and I keep fighting against it. One of my successful arguments has been that you cannot conflate 101 and 103. You have to present the analysis separately. Examiners don't seem to understand that part, and then I have to explain to them over a call, and I usually call them their supervisor into that call, that look, what is this guy doing? And usually that seems to work. But yeah, that's what I'm seeing, that if you get into 3600, it's a very bad thing. So you have to kind of design your initial, they're also using AI, by the way, nowadays. As far as I know, the PTO is using AI to direct these patents. So you can game that thing, and you should game that thing for your client's benefit. Because 3600, for some reason, I thought they would improve, but they haven't. In the last 5 years, they stay, delightful. So.
Well,
Can I clarify something you said earlier? Because you said you can't just describe in a claim, I'm using AI and applying AI to whatever you're.
You can, but it'll.
Okay, right, but it's probably likelihood of a rejection.
Yeah.
When you say that, are you talking about it's more of the description of AI? Or are you saying, right? I mean, because there's different uses of AI. There's companies that have their homegrown, AI versus ones that are using a Claude or a GPT and then just using that as an API through an API interface. So I wanted to sort of clarify what you meant. Is it a description thing, or is it more of a well, you can't do it with, if you're using GPT and Claude, there's no novelty there. I'm just trying to understand.
I understand the question. I'll just quickly tell you where I think, and I also distinguish one more sliver from it. So the key here to understand is that there's a patentability issue, there's a trade secret issue. In your case, what you're saying, when the work is going on in-house, there'll be a significant amount of fine-tuning they would have done to the model itself, right? And that's probably a part of your trade secret, but not necessarily, okay? If it tweaks it enough that the input and output parameters change, then it's actually no longer a trade secret. It's you can detect it. Now, as far as how much to put in the claim, there are two yardsticks for me. One is, in the spec, I usually try to give examples and some metrics. And the metrics are around how much improvement. Now, like in the past, last 100 years of case law, if you see 10% improvement over an efficiency or cost savings is actually considered enough as a non-obviousness standard. Especially if you go to secondary considerations, it's considered usually supported. It does not conclude that it's non-obvious, but it's a very big support if you can show that. We have also used in the past 132 declarations from inventors or experts saying that yes, and then the examiner has to treat it as an evidence. He cannot treat it as an argument anymore. So we've done that, right? So now imagine that stuff is there in the specification, right? So I want that to be in the claim where I'm saying that this 10% improvement, I'm not saying 10% in the claim, but I'm saying whatever technical maneuvers led to this 10% improvement, those should show up in the claim. Because now I'm demonstrating technical effect, which is important especially in Europe and all Europe-like jurisdictions, right? In the US, it's not that important, but it's then going to be important in other ways. But examiners usually like to see it. Also, very small thing, but I always put my system claims first.
So is it fair to say then that, assuming you get the 10%
Yeah.
improvement from the non-obviousness standpoint, even if you're using like a GPT or a Claude
Yeah.
in combination
Right.
with your proprietary
Yes.
existing technology, that would be sufficient for,
Yes.
for patentability?
Absolutely, absolutely, almost. So in the 5 years I've been working for this company, the first 2-3 years we were doing custom built models, so the entire stack was ours. The next 2 years we are actually working mostly off of the LLMs. So most of the patents we have filed are actually based off of publicly available LLMs, and we've still gotten those allowances. And now, because we have pivoted recently, about in the last year, where we're doing this business AI cloud, which sort of is a hybrid system with small language models and the large language models. So we are now building patent portfolio around that structure, like what enables it. Does that make sense?
Yeah, no, thank you, that was great.
Sure.
Well, that's a fascinating discussion of the architecture. So, how do you go about describing this, in terms of a block diagram, and what level of details you need to go into these the dichotomy of large and small LLMs?
Well, two things, two disclaimers. One disclaimer: the views presented are my own, not my company. That's one. Second, I will explain to the level where I think I will not be spilling over the company's work. But for the most part, there is general awareness, and it's on our company's website. The small language model structure that we typically have in our platform, it's on our website. So from that perspective, it is. I don't think there's any benefit to describing the internal structures or workings of models. I don't think there's much benefit. Unless you can say deterministically that you will be able to identify infringement at a later point, there's no use in filing patents that are dealing with exact tweak of the model, like inside tweak of the model. Better kept as a trade secret, right? Or just publish it so that nobody else can file a patent and come back at you. Those are the strategies I will follow there. But to your question, I would typically go into how the data is being input, what kind of data preparation is being done, what are the exact input models, at what level of processing is the SLM black box doing, and then what is it handing over to the LLM black box, what is the LLM handing back to the SLM, and what is the SLM throwing out in front. It is at these interface points, which you can also detect, by the way. It is these interface points that will actually allow some detectability and therefore enforceability. Those are the valuable patents. Right?
Fantastic. How do you deal with the weighing between keeping something a trade secret versus patenting it? So a prime example is the training process, right?
Mm-hmm.
I suppose training is training. Just feed data in and it just gets back and it just goes forth.
You can say that, yeah.
To what level of details?
No, I actually keep it at that level of detail. I would not tell more than, so let's say, to make it a little more concrete, these patents of Unifor are public, so I can talk about them. Some of them bring specific sort of, the data input is, because a lot of our patents were initially call center based, so it's usually a stereo transcript, which is the agent and the customer is going in as a input. What's coming out is either the intent or if there's an irony or the things like that, right? So to your question, what's training like? At the training, because I'm anyways going to put these entities in the claim, that the transcript is coming in or the output is intent, right? I say the same things in the training part. That the training is based on data that is two speaker stereo. That means stereo means that you can distinguish between speaker 1 and speaker 2, and then you can actually process that internally and then give an intent of, say, speaker 1, who's the customer, which is why he or she was calling.
So if training is sort of the black box, if you will, how do you jive it against like the disclosure requirements for like, make
Yeah,
sure
one file
this skill in
enable.
art has the ability
Enable.
to enable it, right?
You want to handle? I have my views, but I've been hogging the bandwidth. So.
I try to describe them as much as reasonable, but I think the question of what is reasonable to one skilled in the art in litigation in the end is going to go to an expert. And guess what? There's going to be no expert that says, reading this and I don't understand it.
Yeah, it's pretty much that this is the way I explain this to technologists in my company as to what level of detail we need to have, is that imagine that people in another company, our competitor's company, don't know what we're doing. But if presented with a problem or a solution, will they be able to work out the implementation? If the answer to that is yes, you got enough. And in most cases, it is enough because the level of my claim is not more in-depth than, say, an input transcript and an output intent. So because my level of detail is not more than that, I don't need to go into training details more than that. There is more that goes in a lot of times, okay? But we don't need to talk about it. Those are mostly tweaks that may not be even patentable.
Because you're not claiming the training process is
Exactly. And we essentially, what we want to stop, at the end of the day, the reason why I have a single server claim is we want to stop our competitors who are offering the same SaaS through a server. That's what we want to stop. We don't care about what the customer is doing, right? So if in the longer run, because a part of every AI implementation now is that you are also training it as you use it, right? So we don't want to go after a customer anyway.
So that goes into detectability. How do you, because you're a cloud-based system, how do you deal with the detectability of the infringement?
There's no easy answer there. So you just hope that the cloud, you have the customers or your competitors are deploying solutions through the cloud based in the US, right? That's your key. And in most cases, especially in the enterprise class deployments, the cloud servers are based in the US. So we can easily look at the UX, right? And at least get the input and output scenario. That's easy to get through the UX and the documentation. But the other part, which I sort of pride myself in, and I talk about it everywhere, you've heard this before, but about 7-8 years ago, when AI patents, there was a question that should we file patents on AI or not? A lot of people said that we should not, because AI was supposed to be a black box, and why would you file something on a black box? Because you can never detect infringement. And I took the other line saying that, look, in my view, anything that is so sensitive and is so potent will have a different set of laws that will require it to be transparent. It cannot stay a black box forever. And that has come to pass in the last few years. The European AI Act, or most recently, Colorado, California, and now I think one more, Georgia or some other state is actually talking about their own AI Act. Just reading about something. But each of these things will force some amount of transparency. What's also happening is what is called responsible AI. That tenet is also asking companies for ethics and fairness. They're asking all vendors, everybody, now it's an industry-wide practice, to have what are called model cards, data cards, and agent cards. These cards are essentially, how when we buy food, on the back there's a nutrition information. It's like that for these things. So you kind of have your input and output very clearly put in there. That becomes your secondary source for detecting infringement. So to your question, Bao, if it is in the cloud also, that's okay. But if my competitor has servers in the US and I can see the model cards, data cards, and agent cards, and I can get hands on the manual, right, or the UX, I would very likely catch them. And my claims or my focus on patents primarily is on those ones where I can catch them. We do still file some patents that should have been a trade secret, but we file them for, for other purposes, for thought leadership and for that kind of things. But otherwise, most of our claims, you will see, will be very easy to detect infringement on.
Great. Well, congratulations for being a thought leader on AI. I've known a lot of counsel that says, don't patent AI. Because number one, it's hard to get through the patent office, and number two, the enforceability aspect of it, right? But I think the climate is evolving now where those who didn't start on patenting the AI technology, they're gonna scramble to catch up. And that's a long 2-year wait before you get out of it.
Yeah.
So congratulations on that.
Well, I appreciate it. I don't know if it's leadership or not. We'll see how many of these get enforced, right? So we'll know in really 5 to 6 years. And that's really my focus though. And I think as should be everybody else's, that whether we will have an asset 5-6 years ago or just a piece of paper. Or just a piece of
Well, no,
software
it's
now.
more than that. I mean, we work with a lot of startups, and part of the thing that we try to tell them is venture people always ask, well, what's your moat?
Yeah.
Well, if you claim that your moat is fast speed, well, guess what? Vibe coding just removed that. If you claim that your moat is your people, well, you've seen people get recruited, even the founders got recruited away. So people is not the moat. What else do you have? I mean, IP is probably the only thing you have that's defensible. And maybe the fact that you can raise billions of dollars, that might be a moat, but that's only a few, 5 or 6 companies that would be able to claim that moat. So I think that IP has to be that, and we deal with a lot of startups. And because these startups, they don't have the money like you do to file hundreds of patents a year, we tend to go after a very long, deep patent that's 100, 150 pages. And the design of that is to last over a 20-year time span.
Right.
And I learned that lesson when I was at Invisalign, because I protected that Invisalign patent portfolio, and that thing kept Invisalign in business for 20 years. And now you're beginning to see competition come into play. And so...
No, that's very fascinating. Actually, I've heard that story, but I would like you to elaborate more on that story about the Invisalign patent. That was something you told me that you didn't even expect is going to be important. That kind of leans into, even for software, this is also what I say in my company, you never know. What you think is brilliant today is just brilliance, but it may not be, what a user wants. What a user wants may be awfully simple. And it'll just catch hold and it'll make billions and billions of dollars. And you'll say, well, I didn't think of patenting, this was so simple. And that's what you don't want 5 years, 10 years from now. So, but I would really like for you to actually talk about that a little bit at least.
So in the early days, 1999 timeframe, they were first to be the mass 3D printing house of the world. I mean, they had like 20 or 30 of these machines, and that at the time, that was the biggest company, right? So we had all sorts of technologies in 3D printing, in computer-aided design, in scanning of your teeth, in moving your teeth, dental CAD technology, and all of that. So all that was patented, software aspect as well. But in the early days, we described one thing where these retainers had a sequence indication, right? And at the time, people didn't think much of it. Well, so what? You got number 1, 2, and 3 on your retainer. Is that novel? Well, it turned out that simple concept kept away all the advanced. It was much more valuable than any of the 3D scanning technology or intraoral scanning technology or dental diagnostic. The claim was simple. 3 or more retainers, numbered in sequence, designed to move teeth. That's it.
It's a huge, when he told me this thing, I was blown away. You want to talk more about why it's more important? I can talk, I did the research on Invisalign, and I actually know another counsel who works at Invisalign now. And it is such a fundamental part of their value chain, because it so happened, if you'd asked a dentist, they would have said, yeah, this is very obvious, so why bother, right? But I'm glad that you guys patented it, because the entire infrastructure of theirs, right, entire value chain developed around those 3 stages.
We had one competitor that created a 3-stage. It's called red, white, and blue. Look it up. They got blocked out of the market.
Yes.
The red, white, and blue dental realignment system.
So, and at the time you filed this, did you think that this would become something that will knock out competition?
No.
Would you have thought in a million years?
Yeah, that's why we focus on deep disclosure, is because a lot of time what you think is really novel and important in day one, 2 or 3 years downstream, it dawn on you on something else. And so I'll give you another example. We had a patent where the original thing was a wearable device that detected elderly from falling, and it has an accelerometer to trigger an alarm for them falling. So for the first 4 or 5 years, we were prosecuting it as a PERS device, a personal, PERS system. And it dawned on me, and wait a minute, it's a wearable device. It has a battery. It has an accelerometer. It has a Zigbee accelerator. Guess what is that? What do you think that is?
It's the Apple Watch's accident detection system.
A lot of time when you think about it, you have you have a blinder on, and then if you have a deep enough of a disclosure, then 10 years down the road you can think, oh wait a minute, that it actually could cover something else that's even more valuable.
The underlining thing, and I've been doing this 25 years, I think between us we'll probably be close to 50. Both of us agree on this thing. You never know what's going to become important. And it's always happened that what you thought was important usually isn't. What you didn't think would have more value somehow ends up becoming that one thing that the customer wants. And that's just the nature of innovation. It just seems to me that innovation, when it happens, it's what's more difficult to do. That's what's value, which is where usually the patent departments sit. But what's more valuable is what's simple for the user, right? And that's where the value of the patent sit, which is why I think in the past, patent attorneys have not been focused there. I'm extremely focused on the end use case. So,
Yes,
questions?
very much thought leadership there. I don't know if we have time, but do we have time?
No. we can still take a question if there's any, but I think we did interactive, so it was fine. Yeah. No, I don't think so. We have questions, but thank you for your patient listening. Appreciate it.
Thank you so much.